The opening minutes immediately exposed the real weakness in the mother's position. Her side tried framing this like a long-term absence issue, but the father's attorney strategically kept the argument narrow and disciplined. Instead of getting dragged into relationship drama, she focused the court on one thing: restoring contact.
In December, he came to see me. We ultimately got the petition filed in January. It took a while to get Ms. Conine served, but we're here today asking that the court allow contact between my client and the minor children. I think ultimately there will be no contest about paternity. We're asking for, as a temporary basis, every other weekend and one overnight during the week. My client has a safe home that the children are familiar with. Prior to them being removed from his life, they spent ample time with him and his parents, which are obviously the paternal grandparents of the kids. It's been very difficult for my client to go from being a primary care provider to having essentially no contact with his children. So we would like to see that restored. We're asking the court for, as a temporary order, Friday at 6 o'clock through Sunday at 6 o'clock. And then every Tuesday from 6 p.m. until Wednesday at 6 p.m. I think we would stand on that with the goal of ultimately working towards an equal parenting time schedule and some consistency for the children and both parents.
Very well. Mr. Paul, what is your client's position regarding this request?
Your Honor, she objects to the request. Just like Ms. Locke stated, we don't contest paternity. The thing about it is, Judge, is when these two children were born, the petitioner did not refuse to sign birth certificates. He could have done that at the hospital. He chose not to, and he chose to go down this route. Admittedly, Ms. Koenig did move to Oklahoma for employment opportunities. Judge, she would deny that that she has refused all parenting time. She had reached out to him on multiple attempts from August to February, and then finally in February the petitioner said he wanted to see the kids. Judge, it's my client's position that he's basically been a pop-up parent. He kind of flies in and out like a butterfly. Also, within this motion on the parenting time, it basically looks like there is one parent will be doing all the transporting, and I don't think that's workable because Miss Koenig lives in Enid, Oklahoma. If the court is inclined to grant parenting time, I would suggest that they find a equal part, so they meet in the middle, not one person having to drive the whole way.
Okay, where is your client currently located?
Enid, Oklahoma, Your Honor.
And where does the father live?
Your Honor, he resides in El Dorado.
Okay. All right. Thank you. You may continue, Mr. Paul.
Thank you, Judge. I think because of the distance, the Tuesday and Wednesday parenting time is kind of unworkable. I mean, I know this court is more than likely going to order some type of parenting time, and I think we would not have an objection to every other weekend as long as the parties meet in the middle somewhere. I do believe that we need to exchange financials for child support purposes. I do agree with that with Ms. Locke. And Judge, Ms. Koenig would say that, the father's, but by the petition, it says he was actively engaged and he was kind of semi-engaged. And I'm kind of being generous from what I've been told by my client. So for those reasons, I would ask that, you deny the parenting time during the weekday. If you grant every other weekend, we would ask that some exchange be in the middle. And that's all I have, Your Honor.
All right. Ms. Locke, you've heard Mr. Pa's statements to the court regarding a proposal or at least a position that might be taken in this case. Your reaction?
Your Honor, while we did find ultimately Miss Conine in Oklahoma to get her served with a petition, we were not aware that she had permanently relocated to Oklahoma. And I don't know that she's given the impression today that she permanently relocated. We believe that she maybe still owns a home in Greenwood County, Kansas. So if it's true that she's going to reside in Enid, Oklahoma, we would agree that a weekday parenting time at this point will be challenging. We would be inclined to add a night to our weekends, to every other weekend. So that would be Thursday for the exchange through Sunday on the every other weekend schedule to allow more time with the children, with the hopes that the parties can work out a more long-term parenting plan that supports both of these kids and both of these parents. Obviously, we would contest any of the factual statements regarding my client's involvement with the minor children. He was a very active parent so long as Miss Conine allowed that. So if there's going to be questions about evidence on who acted in what capacity as a parent, we would just like to set that over for another hearing, probably a final hearing on this. But as far as the temporary order goes, we would support the every other weekend if that can be extended to add Thursday.
Is your client set up to handle children this small, 2 children, both that probably would need car seats, approved car seats, beds, clothing? He's set up to handle all that?
Yes, Judge. And like I said earlier, when the youngest child was born, he was actually the stay-at-home parent for the first 4 months of his life. And so he is capable and ready to handle both kids.
The hearing changed the second the judge realized the mother's relocation details were unclear. That moment completely altered the power dynamic in the courtroom. Until then, the case was mostly about competing parenting narratives.
What kind of place does your client currently have, Ms. Locke?
Judge, he resides in El Dorado, and his parents' home is where he would reside with the children during his parenting time, which has a separate bedroom for the boys, beds for the boys, anything that would be needed for the minor children.
Okay, his parents know about this?
Yes.
Okay.
They also miss the kids and are excited about the prospect of getting to be grandparents again.
Okay. All right. I trust that if your client, Mr. Pa, is living in Enid, Oklahoma, that even in Oklahoma they have addresses.
Yes, Your Honor.
What is your client's?
It is 2614 West Oklahoma, Enid, Oklahoma, 73703.
Did you get that down, Ms. Locke?
Yes, Your Honor.
Did you know of that before?
I did not, Judge.
I don't understand why a parent would be hiding the residential location of the children from the children's father.
She was not hiding anything.
No. Well, why didn't she tell him then where she was?
I believe she might have, Your Honor. I mean, Ms. Koenig can answer that question.
Can I speak?
You may.
So I have call logs that I can provide from my entire call history from August up until December, or even, proof of my current numbers, call logs. I have text messages where I have texted him from August through December, and then asking him to be involved, like, hey, this is not okay, like, you're not being involved. I have I have attempted to call. I have, like I said, I can provide my Verizon wireless call logs of me calling and it ringing. He didn't have me blocked. I have reached out to him on Facebook on Messenger, which I can provide that also on a new account that I had to create just to contact him. The only time when I lived in Eureka, which when I lived there, it was 30 miles from where he lived. He never attempted to come see, never attempted to do anything on his part. When we last spoke, he ran my car into a phone pole, or into not to a phone pole, but into the pole. We did get into a disagreement and it was heated. I told him, unless it was about the children, I did not want to have contact with him because the only time that he wants to be a parent is when me and him are together. Every time we split up, it would go days, weeks, months. It was always me reaching out. When we did have contact, it was not good on his part. I feel like me living in Eureka and having no support system from either him or his family, because they were not involved. And the only involvement that I had was my mother and her boyfriend. I decided, it would be in best interest where I had a boyfriend that my kids I introduced to the first day we got together. They immediately bonded. He was making trips down for 2 months from Enid every single 3 to 4 days. He'd come down, spend a couple days, hang out. They bonded. David had absolutely no contact with me. He wouldn't answer calls, wouldn't reach out himself when he knew where I lived. I didn't know where he was living because he was staying at friends' houses. So for him to say that he was actively involved is not a thing. When Hudson was born, I did not want him in the hospital because we were fighting, but he was one of the first people to come up there and meet the kids or meet the son. I tried to co-parent with him. Co-parenting was not a thing. On the papers, they also want me to call and do video time, and I've tried calling. David does not want to co-parent. It's never been a thing. My mental health since moving here has been amazing. My children have been in a good place. They each have their own rooms. I'm working full employment. I have a full-time job since August when I moved, or October when I moved here. And it's just all this stuff. I mean, up until me and him talked in February, I was willing to let him see the kids. I've never told him no, even during our most heated arguments. I've never kept those kids from him. So for him to say that I'm refusing is absolutely not true. I've never done that. I've never done that. And up until February, when I said it'd make me a horrible mom to allow someone to be a pop-up parent. And that's the case, that's what he is. He abandoned the kids. I've tried on my end, and it's making it look like I'm a horrible mom and I'm keeping that I moved here, but I moved here and my mom's going to be moving here soon because, of just no support system there. He didn't want to be a dad. He didn't want to sign the birth certificates. He was in the hospital both times when that was the thing. And when Hudson was born, all he cared about was getting that 2-week off work paper signed for proof that he was born. Didn't want to sign the birth certificate. And the doctor that was in there could even testify on that. And then I have my therapist that I've tried doing relationship counseling. I tried doing parenting counseling.
Okay, I'm gonna go ahead and stop you. I've
I'm
tried to give
sorry.
you some latitude here, but
I'm
you never
sorry.
did address the court's question. Why didn't you tell him where you were living, where your children were living?
He doesn't answer calls, doesn't answer texts. And that's the thing is when I reached out for 2 months, he never, anytime that we weren't together, he never wanted to communicate back, never answer calls, never answer texts. And
the mother's long explanation probably hurt her more than helped her because she answered emotionally instead of strategically. She introduced relationship details, new partners, therapy, mental health improvements, work stability, and old fights all at once.
It's like,
okay, all right. You've attempted to answer the court's question that I propounded. All right, here's the realities of the current situation. There's no dispute over paternity. David Snyder is declared by the court to be the natural father of both children involved in this case, LK and HK. So the court makes a finding of paternity in his favor. That said, he has a constitutional right to parent these kids. Regardless of his activity or inactivity in the past, we go forward from here. The mother is now in Oklahoma. The father is now in Kansas. The court finds it reasonable that the father have every other weekend parenting time with both children. He not only has rights to these children, he has responsibilities, and he needs to share in those responsibilities. And it does appear that the father has a plan where he can adequately parent the children involved in this case for a weekend at a time. We're going to start off with a traditional weekend, Friday at 6 o'clock to Sunday at 6 o'clock, starting with this upcoming weekend. We do need to determine an appropriate midpoint between Enid, Oklahoma, and here. If the turnpike is involved, perhaps the Belle Plaine turnpike exit.
Be closer. Yeah.
Are you familiar with that?
Yes, Judge.
It's a public place. There's always people around. Goods and services are available there if necessary. That would be my suggestion, but if you have a better one, Ms. Locke, I'm listening.
We're agreeable to Belle Plaine, Your Honor.
Okay, now that's that turnpike exit, the southernmost turnpike rest stop on the Kansas Turnpike.
Yes.
Okay. That's the location. And I know there's several businesses there, but I'm sure you can find each other. We'll start that at 6 o'clock on Friday, with the parties returning to the same location to exchange the children Sunday at 6. I understand the request for an expanded weekend, but I think that we have to walk before we run. There's been some period of deprivation here. I hope that the mother will do everything in her power to make sure that the children are comfortable with this exchange, to make it easier for them, better for them. You two do need to communicate, however, so we need to determine now how the parents are going to communicate with each other. Ms. Locke, what is your proposal?
Judge, our proposal is text message, but we would not be opposed to a parenting application.
Well, the allegation from the mother is that your client won't communicate with her by text message. So
What? My client says he has communicated and will communicate.
she sends a text this weekend and says, how are the kids doing? He has a duty to respond, in my opinion.
Understood.
All right, we'll start off with text messaging, because I think that's something that's readily and currently available to both parties. And I've seen cases where people are texting 20 or 25 times a day. That's excessive. I think a once a day check-in is enough under most circumstances. Obviously, if anything comes up during your parenting time period, father, make sure you let her know what's going on.
Can I say something really fast?
No, we're not right now. Ms. Locke, I'm going to charge you with the responsibility of drafting a journal entry establishing paternity and setting forth these temporary orders, which the court has issued today. As far as the request for FaceTime and phone in between, he'd be conversing with a 3-year-old on the phone.
Judge, I think the idea is just to be able to see each other in these off weeks so that it is not so long between seeing dad.
All right, Mr. Paw, your thoughts?
Judge, I mean, if the guy is going to finally step up to the plate, I mean, Ms. Koenig just wants support. She wants, she already told this court that she wants an active father in his life. And, He has not shown that yet, but he's got the chance to show that in the future. So I think maybe on Wednesdays, 15 minutes or so, I think is appropriate. It's a 3-year-old. So,
Are you talking
we'll follow
about
any order.
a phone visit?
Yeah, just
Is that what you're talking about?
visit. Yeah.
Okay. Well, to stay somewhat consistent, why don't we make it at 6:00 p.m. each Wednesday? Mothers to have the children available, or either a telephone contact or FaceTime as the father elects each Wednesday. Furthermore, there's a duty of support that comes along with being established as a parent under Kansas law. Court will order that the parties exchange information so that a child support order can be entered effective May 1 of 2026. I think the father has already provided much, if not all, of his information in his original filing papers. The mother's going to have to disclose her income so that an appropriate child support worksheet can be done. Again, that order is effective May 1, 2026.
Child support entered the conversation at exactly the moment the father gained legal footing, and that timing was not accidental. The judge intentionally tied parenting rights to financial responsibility.
I don't want to have this journal entry of paternity held up, Ms. Locke. I hope that you can get with Mr. Paul and get the child support issue and worksheet accomplished as part of this first order. If there's going to be a delay, however, or something that the court has to get involved in, we can do the child support by a separate order later if necessary. But I don't see anything that complicated about this child support computation that should cause that. Any questions about the journal entry, Ms. Locke?
No, Your Honor.
Okay. Mr. Paul, anything further at this time that the court needs to address?
No, Your Honor. Thank you.
Okay. The court will just observe for the record that the father initiated a court action, got an attorney, initiated this action, which obviously shows at this point he wants to be actively involved in his children's lives and parent. Whether he's done that in the past or not, the court is going to recognize his constitutional rights to parent and try to set up a parenting plan which is consistent with the best interest of the kids. So I expect the parents to work together as a team for the best interest of these two little ones. They deserve to have cooperative parents working together for their best interests. And I hope that each parent sees that and will work with the other to the extent necessary to make things as good as they can under the circumstances for these two little ones. All right. As far as where we go from here, Ms. Locke, what is your suggestion?
Judge, we would like to set a date for a final hearing. If necessary, it's possible that Mr. Paul and I, after a few months of visitation, will be able to reach an agreement as far as a permanent parenting plan goes.
Mr. Paul?
I think that's reasonable, Your Honor.
All right, Mandy, let's look at a possible date in the second half of June or early July. And counsel, this next setting is going to be a 1-hour setting by Zoom. I'm going to be optimistic, and I'm sure that you're going to show up this next court date with some agreed upon parenting plan orders and have everything settled.
I like your
Being
optimism.
eternally
Judge.
optimistic. All right.
Judge, we have July 6th open all day.
Okay.
That's Monday.
So look at your calendars on July 6th, counsel.
And 7th.
Either of those days work for me, Your Honor.
Me as well. I have a hearing on the 7th at 9. Otherwise, I'm free both days.
Okay. I'm going to set this July the 6th at 10 o'clock a.m. It's a 1-hour setting by Zoom. Again, I encourage the parties to work together to try to reach agreements regarding a parenting plan to be implemented from this point forward.
And Judge, that was at 10 o'clock? Your
Yes.
Honor, was that at
Yes.
10 o'clock? Okay.
Yes, 10 o'clock, July 6th.
Yeah, you froze up for a second, Judge.
Okay. Well, hopefully I've thought out and everyone can hear me now. July 6th at 10, 1 hour setting by Zoom. All right. Mr. Paul, anything further
No,
that
Your
we need
Honor.
to address? Ms. Locke, any further clarification from the court needed?
No, Your Honor.
All right, good luck to both parents in working together.
Can I say something really fast? Like
Really
really
fast.
Is there any way we can start next weekend? Because if I do a meeting this weekend, I'm gonna end up losing my job for a no call, no show. My boss that does her schedule, she just went out on vacation, and this has already costed me a lot that I wasn't expecting. But I'm not disagreeing on any of this, like the meeting and stuff. Like, I'm not happy about it, but I'm willing to do it. But can we please start next weekend? Because then
Okay.
my schedule comes out Saturday, and I can tell them that way I can meet. Because I
So,
don't have any other.
so you're working at 6 o'clock p.m. on both Friday and Sunday?
I can provide proof of my schedule. I work from 4. I work evening shifts because my boyfriend works 3 a.m. until 2 p.m. and I work every night. Today I took off just so I could have this meeting, but I work every night. So I would be willing to do it if I could just make sure I can make it to Saturday where they put the schedule out, because we do weekly schedules, and then I can ask to work a morning shift or something. I don't want to. I want to have communication with you so that way you can relay it to them or how whatever. But this weekend just is not going to work because it's going to cost me my job.
The ending completely changed the emotional tone of the hearing because the mother finally sounded practical instead of combative. For the first time, she stopped arguing about the father's history and focused on employment stability. That made her sound more credible immediately. Even more important, the father's side did not resist the request. His attorney agreed flexibility was reasonable, which gave the father a calmer image right before the hearing ended. That mattered psychologically. Judges remember the final emotional impression more than people realize. The court also rewarded cooperation instantly by delaying the visitation start date. That outcome quietly taught both parents the same lesson. Compromise gets results faster than confrontation. The judge's praise of the father's flexibility was another subtle signal. Throughout the hearing, the court repeatedly encouraged future teamwork while warning against emotional escalation. By the end, the case stopped looking like a fight over blame and started looking like supervised reconstruction of a broken co-parenting system.